I met a puppy as I went walking. We got talking, puppy and I. Where are you going this nice fine day? I said to the puppy as he went by. Up to the hills to roll and play. I'll come with you, puppy, said I. Well, that is the classic A. Milne poem, Puppy and I. That is very much not a description of a different dog, a different puppy, you might say, that we're going to encounter today on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, July 23rd, 2024. And yes, we are going to have a case today from the Federal Courts of Appeals about a dog named Thor, who apparently was not man's best friend, not even a policeman's best friend, at least in one specific instance that we'll be discussing. Now, after that, I am going to talk about a case that has to do with voting rights, segregation, Jim Crow, the Eighth Amendment, all kinds of things. So that's coming up later in the show. But first of all, we're going to hear from my colleague here at the Institute for Justice, Dylan Moore, and this case about man's best friend. So Dylan, welcome back to Short Circuit.
Happy to be here.
So this is also a case about qualified immunity, which is one of our mainstays, unfortunately, here on Short Circuit. So, but I don't think we've had qualified immunity about a dog before, not in this way. A few years ago, there was one case that a lot of people were hoping the Supreme Court would take about qualified immunity and a dog biting someone in one way and not in another way, and whether that gave qualified immunity. I remember there was another case about a police officer shooting someone's dog when it was completely unprovoked, and whether that should give the police officer qualified immunity. But now we have your case, and your case not only has a dog, but it has the very unusual fact pattern of one police officer asking for qualified immunity, but another one very much not wanting qualified immunity. So what's going on with that?
Yeah, it's an interesting one, and it's one I think that you'll see falls along the lines of a hyper-fact-specific qualified immunity ruling. So in this case, it's called Irish versus McNamara, and it was decided by the Eighth Circuit on July 18th of this year. I think the overarching theme here is qualified immunity is bad for all of its victims, even when those victims are themselves government employees, which does happen maybe more frequently than people would think. So in March 2022, police were hot on the trail of a suspect. The suspect first led them on a high-speed vehicle pursuit, and that vehicle pursuit then ended in a foot chase. So after the suspect exited his car, he made a break for it, and he scaled a cemetery fence, trying to, book it through the cemetery to evade the cops. And it's unclear whether this guy, Officer Keith McNamara, was part of the high-speed pursuit, but according to the opinion, he arrived to the cemetery within seconds, and he, alongside his faithful companion, Thor, scaled the cemetery fence and began pursuing the suspect.
It's pretty impressive, by the way, the dog getting over that fence. But
there are some crazy videos of like the Belgian Malinois climbing trees and stuff. These police canines are crazy good at climbing. But at about the same time that Officer McNamara and Thor begin pursuing the suspect through the cemetery, another officer, Daniel Irish, begins driving to the cemetery. And so as he's driving there, he's discussing, the description of the suspect with other officers on the radio. And never during this conversation did those other officers mention that a canine was on the scene. So in the rain and with police sirens blaring in the background at night, Deputy McNamara unleashes Thor, they hop over the fence, and he tells Thor, go get him. And obviously there he's talking about the suspect. But within about 35 seconds of Officer McNamara issuing this command, Officer Irish pulls into the cemetery in his squad car. And he starts driving towards the direction where he thought the suspect was going. And at that point, as soon as Thor, the canine, sees Officer Irish's squad car, he starts taking off after the squad car instead of the suspect. And so as soon as Officer Irish opens up his squad car door, Thor attacks him. And he bites him and he restrains him.
I'm just going to say that dog could use a bit more training if a squad car doesn't tip him off to like this is probably a good guy.
Yeah, and when Officer Irish is trying to, call Thor off and saying, get off me, get the suspect, go get him, the dog just doesn't listen. And by that time, Thor, I mean, he's a police dog. He had left Officer McNamara, his handler, in the dust. So he was too far away to call Thor off himself until he could finally run and catch up to the squad car. And so Thor just kept attacking and biting Irish until McNamara eventually got there and was able to call him off. And despite his injuries, I mean, Irish is a bit of a trooper here. He kind of collected himself despite being what the Eighth Circuit called bloody. They don't really talk about how bad it was, but they said he was bloody. Irish collects himself and then helps McNamara sick Thor on the suspect. So in what I can imagine was a great day for Thor getting to bite two people, it was not a great day for the suspect or for Officer Irish. So after they apprehend this guy and the dust settles, Officer Irish sues Officer McNamara for violating his Fourth Amendment rights to be free from excessive force and unreasonable seizure. So according to the complaint, when McNamara released Thor into the cemetery, he told the canine, "Get him," which to the canine means attack the first person that you see. And as we now know, that first person ended up being Officer Irish and not the suspect. So Irish also claimed that McNamara failed to give what's called a canine warning, which is this requirement under the Fourth Amendment where if you're about to sick a police dog on somebody, you have to tell them that you're about to do that so that they have the opportunity to surrender. And Irish basically alleged, because there was no canine warning, I didn't know there was a canine until I opened the squad car door and got attacked. But McNamara moved to dismiss the complaint on qualified immunity. And in maybe a surprising turn, the district court said, well, this is a highly unfortunate circumstance, but no qualified immunity here. This was clearly a seizure under the Fourth Amendment because the dog restrained Officer Irish and through force stopped him from being able to leave. But on appeal, the Eighth Circuit disagreed. It found that McNamara's decision to release Thor into the cemetery, which obviously led to Irish getting bitten, wasn't a clearly established seizure under the Fourth Amendment. And the Eighth Circuit explained a little bit that a seizure requires a physical force that restrains a person's freedom of movement through means intentionally applied. And that means intentionally applied is kind of where this case hinges. Because in general, this is an objective question. So if an officer intends to seize somebody, then even if they seize the wrong person, it's still a seizure. But what Officer McNamara argued was here, the Eighth Circuit should adopt a subjective intent test. So in other words, he wanted the Eighth Circuit to find that unless he intended to seize Officer Irish, which obviously he didn't, he was intending to seize the suspect, then qualified immunity should apply. And the Eighth Circuit agreed with him. It found that because McNamara didn't sick Thor on Officer Irish, then it wasn't clearly established that Officer Irish was even seized by the dog attack. And that's kind of strange. It is sort of an exception to the general Fourth Amendment rule. And here, even though Officer McNamara clearly intended to seize somebody, the Eighth Circuit held that the Fourth Amendment wasn't violated when that person just happened to be Officer Irish. And you know, what's even stranger about this is that in 2005, the Eighth Circuit had a different case called Sazbla, where they found that there was a seizure when an officer's canine was pursuing one target, but ended up biting another. So what's the difference, right? Because they seem really similar. And I'm not sure I can, find a real difference there, but I'll tell you what the Eighth Circuit said. So they said in Sazbla, the officer didn't know that the person who got bit was not the suspect. The officer thought that the person that the dog eventually apprehended might have been the person that he was looking for. So subjectively, he intended to seize that person. But here, it was obvious from the jump that Officer Irish was not the person that Officer McNamara and Thor were looking for. And Irish was not the intended subject of the seizure, so there was no seizure. And this kind of leads us to a weird rule that the Eighth Circuit has come up with, in specifically the hyper narrow context of canine dog attacks, which is if the officer knows that the person who gets attacked is not the person that they're looking for, qualified immunity. But if the officer thinks, well, maybe the person that my dog bit is the right person, then no qualified immunity. Uh, which is just, it's strange because the outcome is the same. Like, the wrong person is being bit in both cases. And it's odd to me that someone's Fourth Amendment rights would turn on whether the officer who released the dog knew that the person who was bit was the right person. Um, and so, in a way, the Eighth Circuit's kind of created like an "I didn't mean to" exception
Mhm.
to the Fourth Amendment in this context, and that's just not something that we see very frequently.
Yeah, I was trying to think of parallels to this in other Fourth Amendment contexts, and it's really hard to come up with them. So you could say, I mean, I think in some ways, in the back of the court's mind, it's kind of thinking of negligence, right? So, and if you sue someone for negligence, put the Constitution completely aside. You just sue someone for negligence. They You don't have to have intended, of course, because it's negligence, to do something to someone in order to be liable. So if I crashed my car into yours and I was negligent, I wasn't trying to crash my car into yours, and I guess you could say that's like a seizure, right? But with the court's kind of saying, well, with a constitutional tort in the Fourth Amendment context, we think you need some kind of intention to do that seizure or I guess search. But that kind of falls apart when you think of other ways this could come up. So if the police have something you know a bit about, Dylan, if the police say go into your home and search your home, but they were meaning to search your neighbor's home and instead by accident they search your home, that's still a Fourth Amendment question. Right? They
Right.
can't just say, "Oh, sorry, yeah, no Fourth." Like, say they find evidence of a crime in your house, like you can still suppress that stuff if there's a Fourth Amendment issue, which there probably would be. So I think it's like the court is trying to do what courts often do, which is get rid of the case on like the seizure question. Whereas, like, say this had been a seizure, which it pretty obviously to me seems they could then go to the next stage, which is it reasonable? Which is in the
Right.
Fourth Amendment, right? And that would be God knows how that would go with the whole them both being officers and the circumstances. That would be kind of, I think, a more interesting, closer call. Like, how does the reasonableness even apply in this kind of context? And they're, you could look at that they were working together, blah blah blah, or a dog being, having all kinds of things to do with the fact pattern. But instead, they want to get rid of the case as quickly as they can, so they do this reasonable thing, or the not reasonable thing. They do this seizure thing in the specific dog cases where there's a case on point, pretty much saying that that's wrong.
Well, and it's
So
just strange to
it
me.
just makes it even the case law even more messed up in this area.
Yeah, and it's strange to me because, I don't know, maybe it wasn't unreasonable that this happened. Like, maybe, in a big empty cemetery, if you sick your dog out there and tell them to go after the fugitive, and then somebody else comes in that you weren't expecting to be there, maybe it's not unreasonable for you to have released the dog to try and get the fugitive. But if the wrong person got bit and restrained, it's certainly a seizure. Like, it is frustrating to me that they want to bounce it on this weird categorical question of seizure or no, rather than sort of getting into the heart of the question and the Fourth Amendment question, which is, was it reasonable? And
Right.
I agree with you. That seems like that's kind of where the interesting uh, discussion could be had. But this just seems strange.
Yeah, because I mean, this is now going to affect the next case where, say, it's much more. Say there was just when someone visiting their family grave, and they didn't know there was a fugitive or a hot chase or whatever, and a dog comes out of nowhere and bites them. It seems under this case that's not a fourth. That's not even a seizure, and so
Right.
they would have no 1983 claim whatsoever. That's much more sympathetic than this police officer, who actually is pretty sympathetic that
Yeah.
a dog, got to him. He was probably, maybe he should have been more careful opening the door, but he's like, well, it'll recognize I'm a cop and it'll be fine. Or, I mean, who knows? Maybe he came out of nowhere. It doesn't stay in the actual opinion, it seems. But yeah, it's going to have downstream effects that are not good.
Well, and every time a canine bites the wrong person now, the officer just has to say, "Oh, well, I didn't intend for the canine to bite that person.
Right.
They clearly weren't a suspect
Right.
of mine," and that just seemingly forecloses the whole inquiry now.
Yeah, this is the other thing. It's a very cinematic opinion. It was written. It was not like the greatest legal writing I've ever seen, but how it's set up was by the court was kind of interesting. It's a rainy March afternoon, which often it took place in Minnesota. So often Minnesota, you got a lot of melting snow that kind of year, and it's just dreary out. And then you got this cop and his dog driving over the fence. And anyway, I don't think they're going to make a TV movie out of this one, but
I could
interesting
picture
to
it in my
see.
head though.
Right. And then the police officer asking for qualified immunity against another. I have not seen that before, but as you say, government employees suing each other and making 1983 claims. I bet it does happen much more often than we would suspect.
Yeah, it happens quite a bit in sort of the First Amendment, like employment
Right.
retaliation
Right.
situation, less so in these law enforcement contexts. But it's something to keep in mind that, qualified immunity doesn't just affect non government people. I mean, if you're somebody who works for the government and you're wronged by your fellow public employees, then you can run into this issue as well, just like anybody else can.
Right. And I'm guessing the reason why there was a 1983 suit is there's some, state immunities where a normal course of a workers' comp claim, you might even say, probably was not going to get this officer very much, and so went to court. I'm betting the bites were pretty bad too, but
Yeah.
we don't need to get into any of that. Well, that's the case for the dog lovers out there. Now we're going to move on to voting rights, although not very good if you're into voting rights. This case has a lot going on. Dylan and I were just talking in the green room before recording that talking about every jot and tittle of this case would take several episodes. So we're not going to do that. That's not what we do usually on Short Circuit. But I will give a brief summary of the case. But before that, I have to give a brief summary of the background because there is a lot of history here, as there often is in constitutional law these days. So this is a Fifth Circuit case for en banc. So the full court ruled on this case, all 18 active judges, non-senior judges in the Fifth Circuit. It's Hopkins versus Watson, just decided a few days ago. And there were 5 judges in the dissent, but other than that, all of the judges were in the majority, written by Judge Jones, which is interesting for reasons we'll get to in a moment, because she wrote a previous a case that impacts this case. So at issue is part of the Mississippi Constitution that disenfranchises, so it makes it so you can't vote for a lot of convicted felons. And that, of course, is fairly common, less common than it used to be, but fairly common across the United States. What's a little bit more makes it more of an imposition on the right to vote than in a lot of states is it is a lifetime ban. So if you are convicted of certain crimes, and the crimes in the current version, not the older one we'll get to in a moment, but the current version are murder, rape, bribery, theft, arson, obtaining money or goods under false pretense, perjury, forgery, embezzlement, or bigamy. Bigamy is kind of interesting in there. We'll set that aside. We'll actually come back to that later. But if you're convicted of those crimes, most of which in most cases are felonies, then you're going to lose your right to vote for the rest of your life. Not while you're serving your sentence, which is how it is in a lot of cases, including probation, but just the rest of your life. Now, murder, you might not have a quibble with that, perhaps, but say someone's convicted of theft a long time ago, early in their life, in their teens even, and then they're 50, they're completely reformed, they still can't vote. That sounds like quite an imposition on somebody. And so there have been challenges to this over the years. The current challenge, the case that we're talking about today, is an Eighth Amendment challenge, saying that this is cruel or unusual punishment, which the court says it is not, and so they lose. But there's the backstory on how they get there. So this provision comes out of the Mississippi Constitutional Convention of 1890. So the current state constitution goes back to this convention. Now, the Constitution, like a lot of state constitutions, has been amended many, many times since 1890, including this provision, which is very important. But in 1890, everyone admits that this provision, a lot of other stuff in that Constitution, was explicitly done to entrench white supremacy at the time. This is one of the retrenchment constitutional conventions of the era. So in the ex-Confederacy after the Civil War and Reconstruction, a lot of all of those states, in fact, because they were mandated by Congress, adopted new constitutions. So Mississippi was one of them. They adopted a constitution in 1868 under the mandates of the Reconstruction Congress. Years go by, Union troops leave the South, Reconstruction ends, and one after another, the states retrench. And so in 1890, Mississippi did that with its constitution. So the original Section 241, it's now called, in the Mississippi Constitution, the original version, amongst other things, said you lose your right to vote, or basically you can't register to vote if you have been convicted of bribery, burglary, theft, arson, obtaining money or goods under false pretenses, perjury, forgery, embezzlement, or bigamy. Now, notice that list. It's all like property crimes and then bigamy and perjury. Again, we'll get to bigamy in a moment. There's no murder or rape, though, right? So, like, what's going on with that? That's weird. And the reason for it is, although on its face it is racially neutral, it very much was crafted to go after what was perceived, at least. I don't know the reality. The reality was probably close to the perception. But these were perceived to be black crimes. So at that point, of course, freed blacks in Mississippi, often they were, well, not often, they were almost entirely poorer. They were often transient because migrant black laborers would move around looking for work. And so they're more likely to be convicted of these crimes than, say, murder, which was more a racially neutral crime. So they're not going to put it in there. And at the convention, everyone knew that this was what was going on. Now, bigamy is interestingly in there. We had this in our newsletter last week, which if you're listening, you're not a subscriber, you can go to shortcircuit.org and subscribe to our newsletter. And in the summary for our newsletter, we said, like, by the way, does anyone know why bigamy is in there? So I tried to do some research. I looked at the Constitutional Convention Journal of 1890. Like often happens, there wasn't really an indication why bigamy was in there. I think it was just perceived as a black crime. And I think that may have partly been because, of course, blacks are more likely to be illiterate. And so their marriages or their divorces are less likely to be recorded. So it's probably easier to gin up like a bigamy charge if you're charging a black man than if you're charging a white man. And I say man because at that point it was still only men of either race could vote. So that's the history. This has unequivocally, no one argues that this original version of Section 241 would be constitutional today. Over the years, though, it's been amended, most importantly, to put murder and rape in there. It's been changed in other ways. There's other parts of the section that I didn't quote that have been changed. And so a few years ago, just a couple years ago, actually, the Eighth Circuit en banc said this is constitutional because the racial taint has been removed by those amendments. This goes back to a case from the 80s, which was unanimous. The whole Supreme Court said this, that if a provision was adopted with racist intent, and even today, if it's not enforced with racist intent, it's still unconstitutional because the taint follows it. But they said the taint has basically been whitewashed, you might say, out of this provision. So it's constitutional. And that was sorry, Dylan?
Yeah, and just to be clear, like they were able to get around the racist taint of this section of the Constitution just by adding a couple more crimes.
Yeah, there was more to it than that. This is the en banc opinion from a couple years ago. but that did a lot of the work. That that at once those were added, once other changes were made, this happens in statutes a lot of the times. They get fiddled with over the years. So, if you're talking about like the original meaning of the provision, what does that even mean at that point? Because it's been changed so many times. So it was kind of a narrowing of how you talk about racist taint. Now that was trying to overturn an opinion Judge Jones wrote actually in the late 90s, which was just a 3-judge panel that first considered this question. So they said that, and that's an equal protection challenge, right? So it's racist, which is unconstitutional under the Equal Protection Clause, and so it's actually constitutional under that. So that failed. Now I got to bring up one more thing before we get to the current case, which is Section 2 of the 14th Amendment. So dedicated listeners will remember that my old buddy Jared Petnato from my clerking days came on the show a few months ago to talk about his case involving Section 2 of the 14th Amendment and voting rights. So this is one of those, other parts of the 14th Amendment that we don't usually talk about. Section 3 kind of came out of nowhere to be a star earlier this year. That was the Trump v. Anderson case, which we won't go into today. Section 2, though, is also still in there, still in the Constitution, and it's about states losing representation in Congress if they deny the right to vote to people. And in there it says, if you deny the right to vote, we're going to take away your representation, or you should. It's never been enforced, but you should lose your representation. But there's kind of an aside that says, except if you take away the right to vote for participation in rebellion or other crime, which pretty obviously means if you have a bar, say, on people losing their right to vote because of committing a crime, convicted of a crime even, that's okay. So any challenge under Section 1 of the 14th Amendment for the right to vote isn't going to work if it's about convicted felons, because you have Section 2 there. Now, the attempt that I just talked about with the Equal Protection Clause, that's different because that's about the racist taint thing, right? So it's not just about felon disenfranchisement in general. I keep saying felon, but this actually could apply to misdemeanors too. And so you have that to grapple with if you're just across the board challenging a felon bar. So now we get to the current case. And this is now an 8th Amendment challenge. So the 8th Amendment, bar on cruel and unusual punishment, among other things, but that's what we're talking about here. The plaintiffs in this case are people who committed a crime long time ago. The couple named plaintiffs are pretty, more minor property crimes a long time ago, late 90s, and they still can't vote. So they're saying, come on, I want to be able to vote now. This is cruel or unusual punishment. Well, the 8th Amendment is applied to the states via Section 1 of the 14th Amendment, which is right by Section 2, which says you can do this. So you got a question. What argument would you have? Well, this brings in something else in the case law, which is how we interpret the 8th Amendment and the evolving standards of decency line of cases. So the Supreme Court has said over the years, starting, say, 50, 60 years ago, and continuing until relatively recently, that certain punishments can be unconstitutional because they are cruel or unusual now, even though they didn't used to be. And this has some purchase, right? Because cruel or unusual, it doesn't say cruel or unusual in 1791 when the Bill of Rights was adopted, or in 1868 or whatever. It just says cruel or unusual. Well, what's the original meaning of cruel or unusual? Even if we're looking at that, maybe we should look at how it's perceived today, because does that mean we only can look at punishments that were cruel or unusual and, whatever the time period is?
Right.
So,
I
even
think in parts of this opinion, it seems like that's how the Fifth Circuit wants to read the Eighth Amendment.
Yeah.
But I mean, if the framers wanted to list the punishments that they thought were cruel or unusual, they could have done so. But instead, they, left probably intentionally open-ended language. And I just think that it would be strange to fix our understanding of that language to the things that people thought were cruel and unusual at the time.
Yeah, I think that too. I mean, a lot of people who call themselves originalists look at this language and in other parts of the Constitution as it's okay, right? The original kind of meaning of that would be to apply it to your own time, because otherwise you really have to factually look at, well, what were the actual punishments at that time? And the Constitution mentions the common law in the Seventh Amendment. No one thinks that the framers were like fixing the common law in place. The common law inherently changes over time. So anyway, part now you can believe that about the Eighth Amendment, but then this evolving standards of decency is a way to implement that understanding, and it definitely has its critics. So how it's been interpreted in the past is, say, an example that Justice Kennedy, I believe, wrote this case from about 20 years ago, is that it's unconstitutional to execute someone who committed murder when they were a minor. So if someone's 17, they commit the murder, they're convicted, they can't be sentenced to death because that's just beyond our standards of decency. And how you apply what is the evolving standard of decency, you kind of look at, well, they do this, kind of admittedly suspicious looking sleight of hand kind of analysis where you say, well, 30 states used to do this, but now it's only 15. And it seems like it's actually trending towards, even less than that. And so we're going to say that the standards today are that you can't do that. And the latest one, I believe, is the child rape case, which was in the late 2000s, which said that I think it was Louisiana could not execute someone because they raped a child, because hardly any state actually had that on the books anymore. So this is now being this process, this way of figuring out whether there is an Eighth Amendment violation. They're saying, look, this applies to voter disenfranchisement. Mississippi is way behind the curve on this. A lot of states, even Florida, have made it so you can now vote if you're a felon under a certain, if you go through certain hoops at least. And here, unless you get a governor's pardon, you can't do that. And that hardly ever happens. And so, or it's, I think, a 2/3 vote, both houses of the legislature. And so this violates the Eighth Amendment for that reason. Now, from everything I just laid out, there's a number of roadblocks you're going to hit when you're trying to make this argument. I mean, almost all of these, if not all of these cases that the Supreme Court has applied in this context are capital cases. So you're going from capital cases, executions, down to losing your voting rights in one fell swoop, right? There's not a lot of case law on, say, 10 years for a crime versus 2 years for a crime, or even like fines or what have you. So that's a roadblock there. Another one is that whether this is even punishment. So the Fifth Circuit does a bunch of stuff that I think every step, maybe more or less people are going to disagree with it, but it goes through them all. It doesn't just say you lose on this grounds and then for you're done. I think they're like, we're here, we're the en banc court. We're going to do everything. And so for the plaintiffs, it was like, lose, you lose. And even if you won there, you lose here. And even if you won there, you lose here, lose. And that was the case. And it took quite a while to get there. But at the end of the day, they say this isn't even punishment. Taking your voting rights away isn't punishment. I thought that was pretty outlandish, but that there's some kind of case law for that. And then they went into that it's not evolving standards of decency. So, Dylan.
Yeah, the thing that stuck out the most to me is what you mentioned right at the end there, which is the court saying that this isn't even a punishment. And the dissent, I think, rightfully kind of calls them out, because elsewhere in the majority opinion, they talk a lot about plain language. And here, when it comes to what a punishment is, they do a lot of wringing of their hands to get to the conclusion that this is somehow sort of an administrative rule about who should be allowed to vote. And it is not a punishment for a crime, except for the fact that the only way this rule comes into play is if you are convicted of a crime. Right. And it's just strange to me that you could ever conclude that stripping away someone's civil rights in response to them breaking the law is not a punishment for breaking that law. Because it's just a direct negative consequence for doing the thing. So I don't really know how else you can frame that.
Yeah, it's there's kind of arguable language from prior Supreme Court cases about whether, they should have gone there. But even going there, I just I don't understand. They say at one point, well, the provision also says you have to be 18 years of age. And so it's just, checking a box to be able to vote. So just like a child can't vote, and it's not a Eighth Amendment violation to make a child not be able to vote, the same is true if you're convicted of one of these crimes, which
But that, of course,
one
ignores
does
the
not follow
elephant.
from the other.
Right. That ignores the elephant in the room that the disenfranchisement penalty on felons only comes into play after they've broken the law. And so it becomes a punishment for breaking the law.
Yeah. Yeah.
It's strange to me to analogize it to something like being an out of stater or being a child. And the other thing, you know, the Fifth Circuit kind of tries to harmonize it with other collateral consequences of felony convictions. So something like being able to or being unable to get an occupational license,
Right.
which is actually some work that IJ does in our Fresh Start stuff that listeners should totally go check out. But I kind of go the other way and say those are also punishments for a felony. I mean,
Yeah.
all of it, everything that you can't do after you get that conviction, to me, reads as a punishment for that conviction. Um, and to frame it otherwise is strange to me. Like, you can't just say that it's some administrative rule when the only reason that rule comes into play is if somebody is convicted
Right.
of a crime. Under that definition, like, the length of a sentence is an administrative rule as a consequence for committing a crime.
Yeah. One last thing I'll say about this case is it shows all the tension in the law right now. I mean, this is true at the Supreme Court, but especially in the lower courts, about all the different confluences of different periods of Supreme Court case law, because you have this Eighth Amendment jurisprudence, which the current Supreme Court, I think, would tear up and throw in the trash if it adjudicated one of these, evolving standards of decency cases. I mean, not that they wouldn't think that the Eighth Amendment is frozen when it's adopted, but the whole rubric of evolving standards of decency, I think they think is garbage. But then you have this pretty clear case from 1974 from the same period that says that this isn't an issue because of Section 2 of the 14th Amendment. You have the whole incorporation. What does the original meaning? When does the provision mean? What it is it 1868? Is it 19? Is it 1791? Is it today? And then you have the voting rights stuff, which is also in flux, and this challenges to this 1890 racist constitution and all of that. So courts are going to continue grappling with this until the Supreme Court sorts it out. I don't think it is going to sort it out. At least the current, you might say originalist, you might not say originalist majority, because there's a lot of history there, and so we're going to continue to see these interesting lineups. I could see this case. I'm surprised they got as many as 5 votes in the en banc court, even in the well, not even in the Fifth Circuit. In the Fifth Circuit, other circuits you could go the other way because of this strong case law that the to some extent that the plaintiffs had in this case. So it's an interesting encapsulation of that. I don't think this case is going any higher. I think it is what it is. I think this provision from the Mississippi Constitution is going to have to be changed legislatively, but we will keep our eye on further developments. So, Dylan, thank you for your story of man's best friend, at least to one man, not to another. Thank you all for listening to me rant about voting rights and the Mississippi Constitution. If you would like to learn more, you could subscribe to the podcast, or you could also subscribe to the newsletter, again, at shortcircuit.org. But in the meantime, I'd ask that all of you get engaged.